Welcome to the webinar entitled The ABCs of Safeguarding Investigations in the Republic of Moldova. My name is Angela Cara, and I'm a representative for the Republic of Moldova of the Safeguarding Hub for Eastern Europe, a position hosted by Terre des Hommes Moldova. Some of you have already participated at our regional webinars and know very well that Safeguarding Hub for Eastern Europe is a resource for organizations and individuals responding to the crisis caused by the war in Ukraine, and provides both practical and accessible resources for ensuring safety, which aim to reduce harm to refugees and to displaced persons. We all know that governments, national and international civil society organizations have mobilized to enthusiastically welcome Ukrainian refugees and displaced persons in order to offer them support. While this effort is welcome, the crisis and the response to it pose safety risks, where people providing services to refugees may cause harm, even unintentionally. This can include sexual abuse, sexual exploitation and sexual harassment, physical violence, discrimination, denial of access to services. The investigation of sexual abuse and other cases of abuse is a very important measure in order to safeguard. The organization, the United Nations and other civil society organizations use different standards in order to carry out investigations, to investigate all these abuse and exploitation, and to respond all these worries. The subject of today's webinar is demystifying safeguarding investigations, survivor-centered approach. Today we will discuss with international expert on safeguarding investigations, Mrs. Lucy Haven-Taylor, about the basics or ABCs of administrative investigations in safeguarding responses, as well with national expert and master-in-law Mrs. Aurelia Bagrin about the national framework that exists in the Republic of Moldova with reference to safeguarding. The webinar will introduce basic concepts and terms related to the subject of safeguarding investigations, including principles of fairness and the right to procedural fairness. And questions like who can initiate an investigation? What is the difference between a workplace abuse investigation and a law enforcement investigation? What are the responsibilities of the parties involved? And what happens when the case investigation is completed? We will also discuss the victim-survivor-centered approach to investigations. And now, dear participants, I would like to give the floor to our first presenter, Mrs. Lucy Haven-Taylor. She is a safeguarding investigation specialist. Mrs. Lucy Haven-Taylor is an international consultant with over 20 years of experience in ensuring safety and protection from sexual exploitation, abuse, and harassment in the humanitarian and development field. Lucy advises various international organizations on safeguarding and is a member of various international safeguarding expert groups. Similarly, Mrs. Taylor has also provided evidence to the UK Parliament's International Development Committee inquiry regarding sexual exploitation and abuse in the humanitarian sector. Ms. Lucy, you have the floor. The floor is yours.
Thank you so much, Angela, and good afternoon to everyone joining us. It's wonderful to see so many of you joining this webinar. And I hope that in the course of this webinar, we will help you to understand safeguarding investigations and to demystify the process. Because we're aware that you have probably heard in various networks and forums a lot of reference to safeguarding and PSEA investigations, particularly from maybe donors and UN organisations. And it's been identified by the Safeguarding Resource and Support Hub as an area where many of you have asked for extra support. And it can seem complex, but hopefully in the course of this webinar, we will help to unpack it and to make it a little bit more straightforward for you. So if we could have the next slide, please. And then the next slide again. Wonderful. So what is a safeguarding or PSEA, protection from sexual exploitation and abuse investigation? We hear the term a lot. In our sector, the humanitarian sector, a safeguarding or PSEA investigation is a workplace administrative investigation, such as you would undertake into any kind of workplace misconduct or any breach of workplace policy. It takes place when further information is required to determine whether a staff member or a volunteer or someone working on behalf of our NGO or CSO has breached our organisational PSEA policy or code of conduct or relevant policy for safeguarding and PSEA. Next slide, please. Now, you will hear lots of different terminology in working on this subject. Maybe even in this presentation, we might use different terminology. So this is just a slide to help unpack what we mean by some of these terms. So first of all, safeguarding. Angela's already mentioned it. Safeguarding can be a difficult term to translate. In fact, even in English, it can be a difficult term for people. Not everybody's familiar with it. But what it basically means is that we are looking to prevent harm caused by our staff or volunteers or our programme design and implementation. And that harm, it can be physical, emotional or sexual, harassment, exploitation and abuse. So very simply put, safeguarding is looking at trying to prevent harm caused by us and coming into contact with our programmes and staff. PSEA is another term that you might see, and it stands for Protection from Sexual Exploitation and Abuse, and that's by our staff and volunteers. As Angela says, there's been an absolutely wonderful response in Moldova to people affected by the war on Ukraine, and in the most part, we know that people are motivated by trying to do good, but unfortunately there might be a small number of people who use the opportunity to cause harm when they come into contact with vulnerable or at-risk people. So PSEA, we could refer to it as a subset or a part of safeguarding. It's one of the harms that can be caused by our staff or volunteers. You might also hear us using the term survivor. By this, we mean the person who is or who has been sexually exploited or otherwise harmed or abused. Now, sometimes people use different terminology for this, but the important thing is that the person who has experienced the harm can choose how they wish to refer to themselves. So you might also hear the term victim as well, as some people prefer that. And then Angela mentioned that this will be looking at a survivor-centred approach. And what this means is that the victim or survivor's wishes, safety and well-being remain a priority in all matters and procedures. So how we approach any issues of safeguarding or PSEA, we should be prioritising the person who's experienced it. And by that we mean not trying to prioritise the risk of the organisation or our fear of losing funding or any of the other things that might motivate how we make decisions, but rather it's the survivor that we're thinking of at all times. Next slide, please. And remember, you can ask questions about any of this if there are any terms that you still don't understand or any different terms that you've heard in your work. You know, please do pop that in the Q&A if there's anything you want to ask myself or Aurelia about that. So when does an investigation take place? Well, an investigation is not always a default response to any issues or concerns we might have about safeguarding or sexual exploitation and abuse. Rather, we would go through a series of steps. So first of all, we would look at this safeguarding or PSEA issue. Is it caused by our staff or volunteers? If not, then we simply refer it to the relevant authorities who would deal with any safeguarding or sexual exploitation and abuse issues. If it is perpetrated by our staff and volunteers, the next question is, does it represent potentially illegal conduct? Remember, this is a workplace investigation. However, if what we found is some sort of safeguarding issue or sexual exploitation and abuse that actually represents a breach of the law, again, we would simply refer that to the relevant authorities if it is safe to do so for all those concerned. So sometimes our policies prohibit staff from conduct that is not necessarily a breach of the law, but because of the position of power that our staff and volunteers might find themselves in, we have additional things in terms of conduct that we ask of them. So it might be that there is a potential breach of our organisational policy, but it's not breaking the law. So in this case, we would look to do a workplace administrative investigation. But we would only do this if we need to find out more information before we make a decision. It might be that we already have enough information and we can go straight to disciplinary procedures. But if it's not really clear what might have happened, then that's when we undertake an investigation. So there are only specific circumstances in which we might undertake an investigation. It's not always the default response to these kinds of issues. Next slide, please. And as I mentioned, it's a workplace investigation, as we would undertake into any type of workplace misconduct, for example, fraud. However, there are specific things that we need to consider when we're undertaking an investigation into safeguarding issues or sexual exploitation and abuse. And that is that we are talking about sensitive issues and traumatic experiences. So when we're doing these investigations, there is a potential risk of re-traumatization with the survivor and also possible other witnesses that we need to be aware of in how we undertake the investigation. There might be also potential safety and security risks to the survivor and others involved in the case. And then there might be the case that the person who has perpetrated the sexual exploitation and abuse might not be members of staff. However, as we saw in the chart on the previous slide, they might be members of the public. Sorry, the people who have had harm perpetrated against them might be members of the public. Sorry. So if our staff are causing harm to people who are members of the public, it might be a different set of policies and procedures than it is if it's within the workplace. So what we sometimes refer to as staff on staff, and that can include things like sexual harassment. If both the perpetrator and the survivor against whom the sexual exploitation and abuse is being perpetrated, if they are both members of staff or in the workplace, then there are different and specific policies that deal with this. And they're usually covered under the organisation's sexual harassment policies, but it's worth checking with your organisation where that's covered in the policies. Next slide, please. So what happens in a sexual exploitation and abuse investigation or a safeguarding investigation? Well, first of all, regardless of what we think might be the outcome of the investigation, whether we think that the allegation will be upheld or not, we nonetheless offer support to the survivor. That's something we do regardless of what we think the outcome will be, and we do that straight away. So by support, we mean any support that they might need in terms of psychosocial support, in terms of medical care, if they need access to legal services, we will go ahead and help them to do that. Then in the investigation, we assign roles and responsibilities, and we also develop a terms of reference. Now, the important thing is with roles and responsibilities is that there's a separation of duties in order to maintain transparency. So the person who makes the final decision on the investigation, what we sometimes refer to as the investigation manager, should be different from the people who are carrying out the investigation. That's so that there can't be any prejudice and that there's transparency and separation in the decision making. Once we've gone ahead and developed the terms of reference and assigned the roles and responsibilities, we then review what information is already available and develop a plan for the investigation. We then interview everyone involved, all of the witnesses, to see what information they might have. And that includes the survivor if they wish to be interviewed and any other witnesses there might be. And we also interview what we call the subject of complaint, the staff member or volunteer against whom the allegation of safeguarding violation or SEA has been made. Then we gather all of that information, we analyse it, and we develop conclusions based on that. So usually there are three different conclusions that we can reach. Number one is that the allegation is upheld because we have enough information on the balance of probability to indicate that the policy breach did in fact happen. We might not uphold the allegation because, on the contrary, we have enough information that proves on the balance of probability that the policy violation did not happen. And then the third option is that we do not uphold the allegation because we were unable to get sufficient information to reach a conclusion. So the responsibility is on us as the organisation to collect enough information to uphold an allegation. And if we can't, then the subject of complaint, the perpetrator, their record is cleared. And once those conclusions have then been reached, the report with the conclusions is handed to the investigation manager. They look through the report, they see if they agree with the conclusions. Does all the information that's been presented, does it to them indicate the same conclusions? And if so, then they will make a decision based on those conclusions. Next slide, please. We've mentioned survivor-centred quite a lot, and I just want to share with you here the results of some research that was undertaken recently by CHS Alliance on looking at how we can make investigations more survivor-centred. And these are the recommendations that we came up with in the report, that survivors are considered experts in their own situation and know what's best for them. That NGOs or CSOs should consider whether an investigation is necessary or whether there are other options that they can take forward. That investigations should proceed with the informed consent of the survivor. They can participate or not in the investigation, but nonetheless, their consent for an investigation should be sought. That survivors are accompanied by a support person if they want to be. And of course, the investigations should follow sector standards, should not cause further trauma, and should use trained and experienced investigators. And then finally, we recommend that the balance of probability is used as the evidentiary threshold to make decisions. And you heard me use that term as well in the previous slide. So I'm going to explain a little bit more about what we mean by that. So if I could have the next slide, please. Now, some organisations, when they undertake a safeguarding or SEA investigations, might use beyond reasonable doubt as their evidentiary threshold to determine whether they can uphold the allegation. However, because this is a workplace allegation and the usual standard for, a workplace investigation, and the usual standard for workplace investigations is balance of probability. So what do we mean by this? It basically means that we consider that the incident or issue is more likely to have happened than not. And it's a lower evidentiary threshold than beyond reasonable doubt. Now, beyond reasonable doubt, as you can imagine, is very hard to determine in issues of sexual exploitation and abuse and other safeguarding concerns. They usually happen when there are no other witnesses, and it can be seen as one person's word against another. However, there are ways in which we can still make a decision. For example, there are other things like documentary information. We can look at things like WhatsApp messages. We can see if there was anybody who encountered our survivor shortly after the incident, who saw him or her being distressed. There are lots of other ways in which we can determine that on the balance of probability, we can either uphold or not uphold the allegation. So next slide, please. So what happens next after our investigation? Well, as I say, there's a decision made based on the conclusions of the investigation. If the allegation is upheld, it may go to disciplinary procedures. And Aurelia is going to talk about this and some of the other issues around labour law around that after me. If, as I mentioned, if the allegation is not upheld, then the staff member or the volunteer has their record cleared and continue their work. Support to the survivor continues for as long as that person wants that survivor. And then finally, I've put a question mark on this. The final point is justice for the survivor. Now, we've spoken a lot in this sector about what we actually do in terms of reparations or compensation for survivors, and it's a very open discussion at the moment to which we don't necessarily have that many answers. It's a very live discussion. Should we provide compensation to survivors for the harm that was caused to them by coming into contact with our staff or volunteers or programme? I'd be interested to hear your thoughts on that as well. So that's what happens next. If we can move to the next slide, please. So that was a very brief overview or a brief journey through investigations. I'm sure you may have questions on that, but also there's further help available as well, of course, on the Eastern Europe Safeguarding Resources Support Hub website, which you'll see the link to there. And you can access materials in many languages, including, of course, Romanian. And there's also a more detailed how-to note on survivor-centred investigations, which this presentation was based on. There is also a help desk that you can access, which again is available in several languages, including Romanian, which you can get up to 3 days completely free support from a safeguarding expert for any questions or issues that you might need help with. And I very strongly advise you to take this up, because this is a great opportunity that you can get this free support from experts. So I think I'll leave it there for my presentation. And I will hand you back, I think, to Angela to introduce the next presenter. Thank you very much.
Thank you very much, Lucy, for such a comprehensive and explicit presentation with practical recommendation regarding the investigations of safeguarding. Dear presenters, in order to present the national legal framework regarding safeguarding, we would like to invite Aurelia Bagrin, who is a legal expert. Aurelia is also a lawyer at the Center of Lawyers, and she's coordinating a project of decentralized assistance for Ukrainian refugees created with the help of Oxfam. Aurelia is also a central figure and also university lecturer, and she's teaching processual right, civil right. And now, Aurelia, you have the mic. Welcome, everybody. I'm very happy to be here, and that we are so many of us connected, which means that safeguarding, it's a very important topic for us all, especially in the current context. And the fact that we are deepening our knowledge in this field is really a reason to be grateful for. And as Lucy said, safeguarding is a crucial and a key concept in the context of interaction between beneficiaries and assistant providers. So it's very important to assure not only on the level of our organization, which creates this safeguarding concept, but to guarantee it on the national legislative level, because also the state has a series of enforcing instruments and mechanisms that it can use when we see an infringement. So in the following, we will talk about these domains, and we will study the different regulations, the different legal aspects that refer to the infringement on beneficiaries, and also refers to the potential sanctions. So next slide. So the first law that guarantees safeguarding of beneficiaries, of course, is the Contravention Code, and especially Article 542. It's basically paragraph 2, which basically sanctions any kind of infringement of equality within the domain of labor law. What does this mean? This would mean that an employer is sanctioned by law when it infringes the law of a beneficiary, when in the context of labor law, and this infringement can be manifested by infringement of the criteria that favors or defavors certain people. For instance, if somebody is walking on the streets and we see a flyer that says, "We are hiring somebody," and next there is written accepting Ukrainian refugees, for instance. So this would mean that the employer is infringing this legal norm, and it could be sanctioned as a consequence. Another infringement would be to intimidate a person. So this is what the labor law says, that the employer has to argument the refusal. And if this is just a formal one and does not include any proper argumentation of the reasoning that led the employer to the conclusion of not hiring, so this constitutes infringement. So this happens similarly when we are rejecting certain people, for instance, in a different training. So in the current context, a series of organizations or legal persons are actually offering trainings. And then if these trainings would be offered only to Moldovan citizens, and from there refugees would be excluded, this would also be an infringement of access to work, because it's an infringement. A similar case is the differentiated remuneration, which means that the same work is paid differently to different people. So refugees talk to me about the fact that they were hired by their employer, but they are paid less compared to Moldovan citizens, even if they are providing the same service and they are working the same working hours. So this is also an infringement of the law of access to work due to improper remuneration of the provided service. And when we when we see these situations, of course, this is an infringement of the labor law, And as a consequence, the employer could be sanctioned according to the law by the state authorities, by sanctions. Then we will talk about Article 69, paragraph 3, which basically refers about hurting the dignity of a person. What does this mean? So basically now I just saw that society became more tolerant, but at the beginning when I started my work, I heard these replies, oh, the Ukrainians are ungrateful or they do not appreciate our efforts, the efforts of the Moldovan citizens. So there were a series of adjectives that had been used that I would not like to repeat. So this basically had the role and also the consequence, as a consequence, they were hurtful to the dignity of the people. So we cannot catalog, we cannot categorize a whole group of refugees based on certain examples that maybe were unfortunate. So of course, this also constitutes as an infringement that can be sanctioned by the state authorities. Then we need to mention another domain, another legal tool that protects the law, the rights of refugees in terms of safeguarding, which is Article 5 and 10 of the labor law, which obliges the employer to include preventive measures that would guarantee the lack of sexual harassment at the workplace, and also to implement non-discriminatory employing categories. What does this mean? Well, if a person, especially if she or he comes, is a refugee, has to have the same rights guaranteed as Moldovan citizens. So this regulation is included in the committees dealing with exceptional or crisis situations, as well as in a series of laws that are protecting refugees. And if an employer refuses to hire a refugee, then so they cannot take into account citizenship in order to favor the Moldovan citizens. So this can also constitute an infringement. Or in case of sexual harassment, the categories of understanding sexual harassment cannot be different. So we need to explain what sexual harassment means. What are the behaviors that qualify as such? And what are the consequences of such behavior? Or sexual harassment in itself, obviously, is a crime, especially if it is manifested with acts that are included in the penal law. Because sexual harassment can be considered not only the context of penal law, but also of a series of regulations that can include a series of other manifestations, a series of other activities. Others that the penal law includes, the criminal law, I'm sorry. And so why does this happen? Well, because the law constitutes sexual harassment only those acts that have a certain gravitas, have a certain gravity, and in many cases, those who do not reach such a gravity cannot qualify as sexual harassment, but they do, and they can be sanctioned, but they depend on the employer's decisions and not on the legal authorities or the authorities of justice. So eventually, employers can sign a series of forms in which they assume respecting certain policies, specifically the ones preventing sexual harassment, if such a case took place. The next legal frame tool is the penal code, which includes the most severe cases of sexual exploitation and sexual abuse. So what are they? These are the most severe cases. So if we're talking about classifying these acts based on the severity of these acts and also of their sanctions, then we have the following classifications. So the first is the labor law, where the maximum punishment means losing a job, or sanctions like fees and money wise, and also losing certain rights. And then the most severe punishment is up to 12 years of jail, or a certain sexual abuse that can be also sanctioned by a imprisonment for life. So for instance, if these acts are carried out against underage persons. If we have a case of sexual harassment, we talk about Article 171, rape, for instance, which means sexual acts without consent. We have Article 172 of the Criminal Code, which basically categorizes the activities of sexual character without acknowledgement, without agreement. Then we have Article 173, sexual harassment. Then we have Article 174, when there is a sexual intercourse with a person who has not reached 16 years of age, or Article 175, activities of sexual character carried out with a young person who is not 16 years old yet. And also talking people into sexual acts who are minors. So now we will talk about how can an investigation be launched at the workplace. So of course now here we need to take into account the labor law, because this investigation is carried out by the employer. So we're talking about infringement, then depending on the situation, the investigation is carried out by the police. But when this happens within the framework of a workplace, then the investigation starts when the employee commits a disciplinary fault. And this can also mean that it infringes a behavioral code that is meant to be imposed in order to prevent these kinds of events. So this code of conduct is there to prevent it. And this code of conduct also establishes what a certain behavioral issue means. So it has to be explained specifically, what does it mean? And then within a certain organization, it constitutes as a disciplinary infringement, and in the other context, it does not. So when labor law talks about disciplinary infringements, of course, refers to the internal rules and the codes of conduct that had been adopted by the employer and which had been made known to the employees. So a certain employee cannot have a behavior without knowing the code of conduct, without being aware that that specific act has consequences, including losing the job. So this investigation at the workplace cannot take a longer time than a month. And so the employees has the opportunity to present proofs, which means that it has the right to defend himself or herself, which means that when labor law is regulating, refers to sanctions when certain codes of conduct are not being respected, including losing a job, then we need to understand that the employee has to have the right to present proof on his or her behalf. And when this sanction is being imposed, then the employer needs to take it into account the gravity, the severity of the infringement. So as labor law considers the individuation of the punishment based on the minimum and maximum punishment time and punishment mode, depending on the gravity. Of course, in this case, there are the 4 cases of sanctions also are in harmony with the severity of the infringements. And thus, we take into account the consequences of having committed such infringements. And I would like to ask Aurelia to somehow sum up so that we also have time for questions at the end. So next slide. So what does an institutional manager do when he or she decided that there had been an disciplinary infringement? What do they do? So they issue an investigation in which they want to understand in writing an explanation about the fact that had been committed, and also the a person who allegedly committed the fact has to also come with proofs, and eventually a legal document is being signed by a representative of the employee, of the employer, sorry. So what we see here that in most cases, not the whole activity can be thoroughly covered. So then, following the investigation of the case, the employer has to come up with a sanction, which can be also an advertisement, which can also lead even to firing, or just can launch a disciplinary procedure and state that they had not been able to say that there had been a disciplinary infringement. But what is very important to know from here is that the employer can launch the investigation before asking any kind of explanation in written from the employee. So the law does not establish the time frame in which the employer has to ask for this explanation. So as a consequence, this explanation depends on the employer, depends on his or her decision, because they do not want to endanger the sensitive informations of the investigation. So the secrecy that has to secure the safety of the investigations. So they can do that before even having the certain proofs such as text message and so on. So this was what I wanted to mention about this topic, and I would like to thank you for your attention. Thank you very much, Aurelia, for such a specific presentation, for details, for a thorough presentation of the legal framework, and I hope it had been very interesting for our participants. And now, dear colleagues, the next program point is the session on questions. So we wanted to ask you to use the chat box. We already have a question that came from Miss Didu Natalia, who asks the following: what would you recommend to civil society organizations who are in their initial phase of implementing safeguarding policies? So until Lucy and Aurelia give us an answer to this question, we have here a series of professionals, and we are very thankful for your participation. So they're professionals who are active in civil society organizations, and they're also active in state authorities working on safeguarding. And we have a colleague, Strike Maria, who answered to this question already. And with your permission, I would like to read this reply, which says the following: based on the organization's experience that I have in Moldova, what I'm suggesting for civil society organizations to do the following. First, to elaborate politics of guaranteeing safeguarding, elaborating a code of conduct, elaborating of policies and internal policies of the organizations regarding recruitment, regarding child protections, regarding personal data protection, and so on. 4, as our experts mentioned already, training of the personnel of the civil society organization, training of the volunteers, of the experts in order to guarantee safeguarding. Thank you very much, Ms. Dediu, and thank you very much, Marcella, for the question, and thank you very much for the reply as well. Thank you very much. And now we would address this question to our presenters, Ms. Lucy and Aurelia as well. So who would like to reply to this question?
I'm happy to go first, Angela. So I agree with the answers given by the colleague. It's important to have some sort of policy or code of conduct in place, because if you don't, then you have nothing to investigate, and you've not made it clear to your staff what is considered to be misconduct. And I think as a basis, particularly when we might be new to working in humanitarian response, just making sure that all staff are aware that safeguarding or sexual exploitation and abuse might be an issue is a really good starting point. So a very brief training for everyone saying, unfortunately, this is something that might happen in our organization, and then that gives them then that means that they're being vigilant and they're aware that this is something that they might need to look out for. And then when we're further along in the journey, then that's when we start looking at developing complaints and feedback mechanisms that mean that the people that we seek to assist can report any concerns they have to us. But just that vigilance and awareness of staff as a first step, I think, is very important.
Thank you, Lucy, for this reply. And now, Aurelia, maybe you wanted to complete the reply and Now, I would like also to encourage the presenters to come up with other questions in the chat, Q&A chat. So what I wanted to say is that till 24th of February, this domain in our civil society organization, I wouldn't say that it was an ignored issue, but we didn't really highlight or didn't really develop these safeguarding policies. But once as international organizations entered our countries and we established collaborations with different civil society organizations in Moldova, so it has become a standard in safeguarding and collaboration between different organizations, different international organizations and civil society organizations in Moldova. So in most cases, it's very important to collaborate only after we harmonize our policies and we include those international standards that are being adopted in safeguarding and in preventing sexual abuse and sexual exploitation. So as a consequence, international organization, before signing a collaborational contract with civil society organizations, they're checking the adopted policies. So basically the internal regulations, the safeguarding mechanisms, and a code of conduct, and also policies regarding sexual abuse and harassment. And they suggest modification in order to comply with international standards. So this is a practice that we see to sign certain forms in which we are assuming our obligations of interacting when interacting with refugees and to respect those means imposed in terms of safeguarding and to adopt a behavior that are respecting these criteria. Thank you very much, Aurelia and Lucy, for the answers. And now, dear colleagues, if you have further questions, we would like to encourage you to write them down and ask them in the Q&A chat. So meanwhile, while you're still thinking in how to formulating the questions, I would like just to mention briefly that because we have resources regarding safeguarding on our website, and we have online modules that are interactive regarding safeguarding, and at the end of which you will obtain a certificate by Safeguarding Support Hub, and these modules are available in English, Romanian, and Russian as well. And on our website, you can also have access to assistance to safeguarding, which also includes rapid counseling regarding the aspects of safeguarding. And this assistance is also available in Romanian, English, and Russian. If we have no further questions, dear participants, we would like to thank you for your participation on today's webinar. We know very well that you have a very full schedule, and this is why we were very happy to be able to have you in our webinar. If you wanted to give us comments, leave us comments on today's webinar, or to suggest us further topics for the next webinars, you could do that via our social media channels, or just write us to info@safeguardinghub.org. Thank you very much. Thank you very much for your participation at our webinar. And I'm encouraging you, dear participants, to visit our website Safeguarding Resource and Support Hub, and you'll see that we have a series of resources that are very useful, very practical for those, for all professionals in the field. And you will see that the online modules that are also interactive will be very useful for you in your everyday professional activity. And you will also benefit of a certificate at finalizing the modules. So modules are available in Romanian, English, Russian, Ukrainian, and Polish. And I would like to give the word to Lucy and Aurelia for their final word.
Sure, thank you, Angela, and thank you, everyone. And just to reiterate again, please do use the resources available for you. Nobody expects you to become experts overnight in this. It's a new area for most people. So please do reach out, because the Safeguarding Resource and Support Hub is here to help you.
We would like to thank you for your participation, and we hope that this information will be useful to you, especially that Angela really made sure to share a series of materials so that you can have more knowledge of the topic, especially if you are a person interacting and active in this civil society context in safeguarding. And hopefully we will be able to meet later on in order to deepen our knowledge and to learn more also on other topics. Thank you very much, dear participants, and we would like to invite you to visit our Safeguarding Hub, Safeguarding Support Hub.org. Thank you very much.